Very good day to all of you. After the 47th GST Council meeting, lot of notifications have been issued, lot of circulars have been issued, giving various clarifications. And we will be giving updates, both in written format as well as in video format, about some of the important notifications and circulars. In that series, first we will deal with the circular issued by CBIC on how to deal with the fake invoice cases. This is very important for the reason that of late, lot of cases are being booked by the department on these fake invoices. There is no clarity as to what type of demand has to be raised. See, nowadays we see the same amount is being demanded from so many people. Whoever is involved in the transaction, everybody is asked to pay the tax. So like that, lot of confusion is going on. So in this connection, this particular circular has been issued on 6th July, providing various clarifications with regard to fake invoice cases, how the demands have to be raised. We will try to understand this particular circular. There are different types of fake invoice cases. There may be so many, but basically we can find out there are some 3 types of fake invoice cases. In one particular segment, a person will obtain a registration. He will start issuing invoices, but without any supply of goods or services. He will supply only invoices. He will file the GSTR1 return promptly so that the details will be auto-populated in the 2A and 2B of the recipient, but he will not file the GSTR3B return. He will not pay the tax. So after some time, before the department notices and takes any action, the person will vanish. So the recipients, they would have received only invoices from this person. Those invoices will be reflecting in the recipients 2A and 2B. They may be taking credit and they would be using the credit for payment of their tax liabilities. This is one particular type of case where these fake invoices are there. Secondly, a person may obtain registration. He will, in the first case, no goods are involved. He is only supplying invoices, no goods are involved. In the second type of transaction, what will happen? He may be able to procure the goods without payment of duty. So there will be a lot of small people who will be supplying the goods without bills. So he will purchase all the goods without bill. And he will get invoices from a different source. He will get invoices from one person and he will get goods from some other source without invoices. And using that ITC, he will make outward supply. The outward supply will be genuine. He will be supplying the goods. He will be paying the taxes also. But whatever ITC he has availed, that ITC, those invoices against which he would not have received the goods, he would have received the goods from some other sources without payment of taxes. This is one particular type of transaction. Another type of transaction, we can call it as a circular trading. So many a times to boost the turnover for bank purpose or for various other reasons, some people indulge in these type of activities. So here what will happen? A will raise supply invoice on B. No goods will move, only invoices will go. A will raise an invoice on B. B will take ITC. B will again raise an invoice on C, again without goods, and C will take credit. And subsequently, C will again sell the goods back to A. So like that, the credit will go as a round, as a circle and come back to A. But in the entire chain of transaction, there will not be any movement of goods. So this is one particular type of fake invoice cases. These are broadly the 3 types of fake invoice cases. And there may be one more variant also, depending upon the situation. There may be some variations from this pattern also. Now, this circular 171 has been issued. This is mainly by way of an instruction to the department as to what type of demand has to be raised in different types of cases. So they are given 3 situations. We will try to see them. In the first case, A issues invoice on B without supply of goods. So no goods are supplied, no services are supplied by A, but only invoices are given by A to B. So based on that, B will be availing the ITC. So B will be availing the ITC. So here, A is not making any outward supply. No supply of goods, no supply of services, but only invoices are raised and taxes are paid. So what type of action can be taken against A? So in the hands of A, in the given situation, there can be no demand of tax because he has not supplied anything. How A has got ITC, that we are not concerned. We are only concerned with his outward invoices which he has been raising. So since he has raised the invoices without actual supply of goods, no tax demand can be made. Even if he has not filed any 3B return, no tax demand can be made from A. But penalty can be imposed on A under section 122(1) class 2. Under section 122 subsection 1 class 2, which talks about penalty for issuing invoices without actual supply of goods. That penalty can be equal to the amount of tax which has been passed on. Any person who issues any invoice or bill without supply of goods or services in violation of the act, they will be liable for penalty. So in our case, A is not making any supply. He raised only invoices. He filed GSTR1. He has not filed GSTR 3B. Based on that invoice, B has taken the credit. Now, no tax demand can be raised against A because it is the case that he has not made any supply. It is only question of invoices, so tax cannot be demanded, but equal amount of penalty can be imposed on A. This is the first clarification issued by the board. Secondly, it's a continuation of the first transaction. B avails ITC on the basis of the invoices given by A, only invoices without goods. B avails ITC and B utilizes that ITC for a genuine purpose. He may be using it for payment of taxes on the outward supply or payment of tax on the export goods and claim of IGST refund. So for whatever purpose, B is utilizing such a credit. So in the hands of B, it is an ineligible credit because he has not received any goods. As per section 16(2), receipt of goods or services is one of the conditions for taking the credit. In this case, B has not received any goods or services. He has received only invoices based on which he has taken the ITC. So action can be taken against B for recovery of ITC under section 73 or 74. So once recovery action is taken under section 74, equal penalty can also be imposed under section 74. So penalty under section 74, which can be equal to the ITC amount, which is proposed to be disallowed. And section 78(13) says, if penalty is imposed under section 74, no other penalty can be imposed. So section 122 will not apply. It may appear there is an overlap between section 74 penalty provision and section 122 penalty provision. We will come to that later. But in the hands of B, who has taken ITC on the basis of a fake invoice, action can be taken for recovery of ITC under section 74 along with penalty under section 74. Once penalty under section 74 is imposed, no further penalty under section 122 can be levied on B. So in the same case, in the hands of A, it will be a penal action. The credit recovery will be in the hands of B. This is the second situation which has been clarified by the board. Thirdly, continuing with the same example, B avails ITC. In the second case, B is using the ITC for some genuine purpose, for payment of tax on the outward supply made by him. But in the third example, B avails ITC on the basis of invoices issued by A without supply of goods. In turn, B is also raising only invoices on C. So there are no transfer of goods from A to B or from B to C. A issues only invoice on B. B issues only invoice on C. So now what is the action that can be taken against B? B has not made any supply. He has not supplied any goods or services, only invoices. So there can be no demand of tax from B. Since he has not supplied goods or services, no tax can be demanded from B. Whether the ITC availed by B can be recovered from B? No, because whatever ITC he has availed, he has reversed the ITC by way of raising fake invoices. So without making any supply of goods, he raised invoices and he used the credit for paying tax on that. So there is no inward supply, no outward supply. So the transaction is neutralized. So B, there will be no demand on B for denial of ITC. There will be no demand for recovery of tax demand also, because he has not made any supply and whatever credit he has taken, he has paid tax on a transaction which is not supported by any supply. So there will be no demand under section 74 in the hands of B. But penal action can be taken against B. See, penal action, the circular clarifies, penalty can be levied both under class 2 and class 7 of section 122.1. 122.1 class 2 talks about issuing invoice without supply of goods. B is issuing an invoice to C without supply of goods, for which he can be levied penalty under section 122.1 class 2. Class 7 talks about taking credit without receipt of goods. So B has also taken credit based on the invoices raised by A without receipt of any goods. So for that also B is liable under section 122.1 class 7. So now the question is whether both the penalties can be imposed. It looks it is possible because B has committed two offenses. One is taking credit without receipt of goods, and second, issuing invoices without supply of goods. So both the sections should be attracted and the penalty can very well be double the amount involved. So B, the double, but there can be no tax demand, there can be no ITC demand. This is what is called as a circular trading transaction, where credit is transferred various hands and finally it is coming back to the original place. Now, if we see the circular very carefully, the following principles are emerging from the circular. So issuing fake invoice is an offense which is punishable with a penalty. So this is the first principle. Issue of fake invoice is an offense for which penalty is leviable. Availing ITC on the basis of fake invoice is also an offense. Whoever is taking credit on the basis of invoices without actual receipt of any goods or services, they are also liable to penalty. If the ITC availed on the basis of fake invoices is used for discharge of genuine tax liabilities, somebody is taking credit on fake invoices and using the credit for payment of tax liability, a tax liability which is actually payable, then this is misuse of ITC. That ITC can be recovered from him. Apart from the penal action, ITC availed by the person can also be recovered. But if that person has not used the ITC for paying any tax liabilities, in turn, he has again issued fake invoices. In that case, such a person can be penalized once for taking credit on the basis of fake invoices, again for the offense of issuing fake invoices, but there can be no demand of tax or no recovery of ITC in the hands of such a person. In fact, way back in even under the central excise era, in one of the circular trading cases, the Madras High Court has held in this case, that is Sujana Metal Products 2021-377 ELT 529, that in case of a circular transaction, the tax demand cannot be made or the recovery of settlement credit cannot be made, only penal action can be taken. So the same principle has been contained in this circular also. So these are all the basis based on which the department has to proceed. So now, if we move forward, Section 73 and 74 talks about the determination of the tax liability, and Section 75 lays down various procedures. Section 73 will apply for those cases where there is no fraud, suppression, etc. And 74 will apply where fraud, suppression is involved. We all know that. Under Section 73, 10% of the tax amount or the ITC amount can be levied as a penalty. If the tax and interest is paid before issue of show cause notice or within 30 days of issue of the show cause notice, there will be no penalty under Section 73. So 74, the penalty can be equal to the tax amount or the ITC amount. If the tax amount and the interest amount is paid before issue of show cause notice, then the penalty will be 15% of the tax demand or the ITC demand. If tax and interest is paid within 30 days of show cause notice, then the penalty will be 25% of the tax demand or the ITC demand. 75(13) says, if penalty is proposed and imposed under Section 73 or 74, no other penalty will be leviable. That is, Section 122 will not apply. Now, coming to 122, it prescribes various types of offences for which equal penalty can be levied, like issue of fake invoice, collecting the tax and not paying to the government, and taking credit on the basis of fake invoice, not taking registration, like that. Various offences are listed out, and for which a penalty is either 10,000 or equal to the tax amount, whichever is higher. So in some cases, tax amount may not be relevant. For example, failure to take registration is one of the offense mentioned in 122. For that, the maximum penalty can be 10,000. So like that, this section also prescribes various penalties, and 7374 also prescribes various penalties. So now, is there an overlap between section 7374 on the one hand and section 122 on the other hand? If you look at it very carefully, whenever any tax is short paid, not paid, any ITC is wrongly availed, or any erroneous refund is granted, if recovery action is taken, along with that, penalty can also be proposed under section 7374. 122 will not come into picture. There may be cases where there may not be a requirement for determination of the tax. Only penal action has to be taken. Then section 122 will apply. Let us say there was a short payment of tax which was already paid by the taxpayer along with interest. But the case involves suppression. So the department wants to levy penalty. So there the penalty will be under section 122. Or he has not, so like that, wherever the tax determination is not involved under section 7374, section 122 will come into play. And wherever tax demand, that is tax determination under section 7374 is taken, penalty also will be taken care of under section 73 or 74. This seems to be the thin line of difference between section 73, 74 and section 122. And in the context of fake invoices, how these provisions will apply, that has been clarified in the circular. I hope this video would have been of some use in understanding this particular circular about fake invoices. There are a lot of other issues, a lot of other notifications have been issued, more circulars have been issued. We will come out with more videos about this. Thank you.